Welcome, everyone. Welcome. I'm Ben Sachs. I teach labor law here at the law school, and it is my great pleasure to introduce and welcome Lina Khan, Chair of the Federal Trade Commission, and to welcome her to HLS on behalf of the Center for Labor and a Just Economy. There is no one who better represents the intersection of antitrust law and workers' rights, who understands the connection between antitrust policy and a just economy better than Lina Khan. Chair Khan studied political theory at Williams College and graduated in 2010 into an economy shaken by the Great Recession. She went to work as a researcher at the think tank New America until she left to help found the Open Markets Institute, where she served as legal counsel. Khan attended Yale Law School and in her third year published the now famous article, Amazon's Antitrust Paradox. The title is a reference to the influential 1978 book by Robert Bork, The Antitrust Paradox, which argued that keeping consumer prices low ought to be at the heart of antitrust enforcement. Chair Khan's article demonstrated why the consumer price model is inadequate in the face of corporations like Amazon. Chair Khan first came to the Federal Trade Commission as a legal fellow. After her fellowship, she taught at Columbia Law School and then returned to government in 2019 to work for the chairman of the House Subcommittee on Antitrust. In 2021, President Biden announced Khan's nomination to the FTC, and following her confirmation by the Senate, Biden appointed her FTC chairperson. She has served in that position since June of 2021. Among her many accomplishments has been prioritizing antitrust enforcement that protects workers. In fact, Chair Khan has brought more attention to how competition law applies to labor markets than any other FTC chair. Appearing on Bloomberg's Odd Lots podcast this November, for example, she spoke directly to this intersection, saying, "The antitrust laws protect everybody. They protect patients and consumers, but they are also supposed to protect workers." She went on to note that consolidation creates not just monopoly power, but monopsony power as well. That is, businesses' power not as sellers of products, but as buyers of labor. And monopsony power can trap workers in jobs, leaving them unable to leverage alternative offers because their employer has swallowed up all the competition. Khan's labor-inflected view of antitrust enforcement has manifested in a number of concrete actions, including the high-profile proposed rule banning the use of non-compete clauses in employment contracts. The FTC estimates that this ban would increase American workers' earnings by up to $300 billion per year. Under Chair Khan's leadership, the FTC also adopted a policy of prioritizing enforcement actions to protect gig workers from unfair, deceptive, and anti-competitive practices. And in an equally important companion move, the FTC voiced its support for organizing and collective bargaining by some independent contractors. In a footnote, see, always read the footnotes, to its September 2022 policy statement, the Commission announced that it will not focus on organizing efforts undertaken by gig workers, alleviating what had been a significant source of anxiety among organizers and advocates for gig workers. Her attention to the interconnections between labor and antitrust and her commitment to ensuring that the FTC serves consumers and workers alike make Chair Khan the ideal person to discuss with us ways that promoting market competition can empower working people. Here, too, is the ideal person to moderate such a discussion, a person who in this room needs no introduction, HLS's own Sharon, Professor of Practice and Executive Director of the Center for Labor and a Just Economy, and author of a book on this subject, the excellent Inequality in the Labor Market, The Case for More Competition. So please welcome Lina Khan and Sharon.
Hello, everybody. Good afternoon. It's such an honor to be here with you all. Thanks so much, Professor Sachs, for the extremely generous introduction, and also to the staff who shouldered the labor and war to make this event happen. Really looking forward to the conversation with Professor Block, and so inspired by her commitment to public service on behalf of the hardworking people of this country, as well as the rigorous and timely research that you and your colleagues at the center are producing. I thought I would just share a few high-level thoughts to kick things off, and then really am looking forward to the conversation. The FTC is not traditionally thought of as a labor agency, but my guess is that many of you in this room understand very well that it can be. Since I had the honor of stepping into this role as chair, I've been reminded over and over of the ways that our decisions deeply and directly affect the well-being of people who work for a living. At our open commission meetings and out on the road, through our comment dockets and through letters to the commission, we've heard time and time again how business practices that the FTC oversees are affecting workers. We've heard, for example, how in some regions the dominant health system has bought out all the major hospitals, such that nurses now live in fear of being blacklisted by the local monopoly, chilling their ability to file complaints or organize their workplace. We've also heard how female drivers in the long-haul trucking industry find themselves stuck in unsafe situations because of coercive contractual terms that effectively force them to choose between putting up with harassment or foregoing their paycheck. We've also heard how screenwriters working in an increasingly consolidated and vertically integrated entertainment industry now face no competing offers for their work, resulting in pay that is a tiny fraction of what they earned 15 years ago, even when they write major hits and deliver huge windfall for the studios. We've also heard how casino workers who were told they would be fired if they did not sign a non-compete clause then watched working conditions worsen and found themselves blocked from taking a job with better employer in the same town. As one casino worker wrote in a comment to the FTC, "This is not the American dream, to be owned or controlled by corporations." Labor law has long recognized that intrinsic asymmetries of power in the workplace can give rise to exploitation, coercion, and abuse. But as markets across our economy have become more consolidated and business models that concentrate control and profits while shedding risk and liability have proliferated, we hear similar stories of exploitation, coercion, and abuse even outside the traditional workplace. Franchisee owners, for example, tell us that dominant franchisors can dictate terms and leave them saddled with crippling debt, accounts that echo what we hear from gig workers subject to the whims of a digital platform. Poultry farmers who have just a single processor that they can sell to live in such fear of retaliation that some even refuse to share their concerns privately with the government, a reality I saw firsthand over a decade ago when entering this field as a business journalist. A basic tenet of the American experiment is that real liberty means freedom from economic coercion and from the arbitrary, unaccountable power that comes with economic domination. You all are extremely well versed in the ways that labor law is an essential ingredient in securing this freedom. I want to offer that antitrust law and competition policy should also be viewed as key tools for securing real economic liberty, checking economic domination, and protecting all Americans, including American workers, from coercion. Just as the Constitution created checks and balances in our system of governance to safeguard against concentrations of political power, Congress wrote the antitrust laws to create checks and balances in our commercial sphere to protect us from concentrations of economic power and the coercion that it could enable. In the run-up to the Sherman Act's passage in 1890, Senator John Sherman observed that, quote, "The law of selfishness, uncontrolled by competition, commands the price of labor without fear of strikes." In crafting the 1914 FTC Act, lawmakers sought to, quote, "secure labor at the highest wage and the largest amount of employment under the most favorable conditions and circumstances," end quote. Labor protective provisions in the Clayton Act, passed just a month later, gave laboring people a Bill of Rights and a Magna Carta. 20 years later, in 1935, Congress passed the National Labor Relations Act, a watershed moment for the ability of workers to counter employer power. Whereas labor law primarily focuses on protecting workers' rights to collectively bargain and organize for shared ends, antitrust law primarily determines the terms on which firms can compete and coordinate. Whether and how we enforce the antitrust laws can be the difference, for example, between workers having the freedom to secure a better job in a tight labor market, or instead being blocked from opportunities that offer higher pay or better working conditions. It can be the difference between workers having the freedom to attempt to organize their colleagues, or instead knowing that if they're retaliated against, there are few, if any, places left to go just so that they can keep food on the table. It can be the difference between workers having the freedom to play employers off each other when it comes time to come to the table to renegotiate union contracts, or instead watching their bargaining leverage shrink as firms merge and labor markets consolidate. Or it can be the difference between workers having the freedom to strike out on their own and start a new business, or instead being locked out of markets where monopolists get away with muscling out new entrants. These are just a few of the ways that antitrust shapes and structures the ability of people of all walks of life to earn an honest living. Through most of the last century, vigorous antitrust enforcement and competition policy were viewed as key tools for structuring markets where consumers, workers, and honest businesses could get a fair shake. As part of a broader philosophical shift in the 1980s, policymakers turned away from a deep commitment to maintaining open, competitive, fair markets in favor of accepting more consolidation across the economy. At the start of his term, President Biden announced a break with this approach. He said, "We're 40 years into the experiment of letting giant corporations accumulate more and more power. Rather than competing for consumers, corporations are consuming their competitors, and rather than competing for workers, they're finding ways to gain the upper hand on labor. I believe," he said, "the experiment has failed." The FTC has been on the front lines of reinvigorating enforcement of the antitrust laws. Our enforcement seeks to protect all Americans, including workers, an aspect of antitrust analysis that enforcers in recent decades had neglected. Being successful in this work requires that we have a solid grasp of how labor markets actually work. That's why one of my top priorities has been ensuring that we are regularly and systematically engaging with the public. Through open dockets, open commission meetings, and listening sessions across the country, we've heard directly from thousands of workers about their lived experiences. Rather than relying just on theories and models imagining perfect competition, we are rooting our work in empirical research and commercial realities, namely the reality of how firms acquire and exercise power in the modern economy, and the reality of how workers are impacted. While there's much more to be done, a few key areas already reflect the fruits of these efforts. First is our work to safeguard against unlawful forms of consolidation that can deprive workers of the benefits that labor market competition can bring. A relatively new large body of empirical research, some of it produced by those of you here today, has revealed that labor markets are far more concentrated than previously recognized, and that increased labor market concentration directly correlates with lower wages. Even in occupations with higher outward mobility, like bank tellers or counter attendants, recent estimates suggest that 1 in 6 workers face wage suppression as a result of employer concentration. The Treasury Department estimated that labor market concentration accounts for a 20% decrease in wages. It's striking, shocking even, that America's workers are making a fifth less than they should be in a more competitive, less consolidated economy. One of the primary ways that consolidation occurs is through mergers. Mergers and acquisitions can enable dominant firms to further amass power over workers, small businesses, and communities. Section 7 of the Clayton Act prohibits mergers and acquisitions where the effect, quote, may be substantially to lessen competition, end quote, including competition for labor. Our new merger guidelines, published together with the Department of Justice and finalized this past December, lay out a framework for considering how a merger may lessen competition in labor markets, the first time that the merger guidelines have ever explicitly discussed labor markets. Informed by thousands of public comments, including many from workers and worker organizations, the new merger guidelines recognize the realities of how labor markets work. When determining whether a firm has power within a labor market, for example, the guidelines note that we will look at direct evidence of the merging firm's power to cut or freeze wages, slow wage growth, exercise increased leverage in negotiations with workers, or generally degrade benefits and working conditions without prompting workers to quit. The guidelines also note features of labor markets that make them unique. Searching for a place of employment is different from searching for a vacuum cleaner to buy. Workers may assess employers not just on pay and benefits, but also on factors like the predictability of one's schedule and how much someone values the work. The high switching costs and search frictions of labor markets can exacerbate how mergers affect workers, and the level of concentration at which competition concerns arise may be lower in labor markets than they are in product markets. The new merger guidelines also make clear that mergers that lessen competition in labor markets cannot be redeemed through benefits provided to other market participants. Fidelity to the law means that we cannot subordinate worker harms to consumer benefits. We must also be clear-eyed about the promises that merging companies make. Merger enforcement is inherently a predictive exercise, but the last 40 years of relatively permissive policy provides a rich history from which we can learn. Merging companies, for example, will often claim that a merger will lead to increased direct employment, only for those promises to fall apart once a merger is consummated. Layoffs, rather than job creation, has often been the norm. Our merger analysis must also recognize how competition plays out in both unionized and non-unionized workforces. Eliminating competition might remove a key point of leverage for labor unions who rely on having a credible strike threat to secure stronger contracts for their workers, as Senator Sherman observed more than 130 years ago. And when workers do strike, like the Writers Guild and SAG-AFTRA did for 4 months last year, consolidated industries may be better positioned to let unionized workers, in the words of one veteran, bleed out before coming to the table. These are the kinds of stories that deepen our commitment to understanding the realities on the ground in labor markets. And this past year, punctuated by historic strikes and a resurgence of labor organizing, offers a rich set of lessons on the relationship between market power and worker power that I'm sure many of you are exploring. Key questions remain, including, for example, empirical questions around how to weigh the trade-off workers can face between leveraging mergers to secure commitments from companies that make life better for workers in the medium term against the long-term loss in bargaining power that mergers can enable. A second key pillar of our work is scrutinizing coercive contractual terms that can disempower workers and reflect unfair methods of competition. A defining feature of the US labor market these last few years is how tight it has been. Although it's not uncommon to see economic commentary claiming that workers can easily leave their current employer and find another job, that conventional wisdom doesn't always bear out. In fact, as many as 30 million workers in this country are bound to their current employer by non-compete clauses in their employment contracts. For these workers, who can range from fast food workers, hairstylists, and janitors, to journalists, veterinarians, and tech executives, changing jobs can be far from easy. It can mean commuting hundreds of miles away from family, learning a new profession, or facing down your employer in court. That's one reason why a top priority for me as FTC chair has been to restore the agency's mandate to safeguard American workers and businesses from unfair methods of competition, a core directive of the FTC Act. While the Sherman and Clayton Acts prohibit a whole set of trade practices, Section 5 of the FTC Act is unique in prohibiting unfair methods of competition. The text of the statute is useful for making clear that the law distinguishes between fair and unfair methods of competing. Or as President Biden put it, quote, "If your employer wants to keep you, they should have to make it worth your while to stay." That's the kind of competition that leads to better wages and greater dignity of work. In 2022, the Commission issued a policy statement laying out how we will interpret unfair methods of competition. Drawing on decades of case law and fidelity to the text, structure, and history of the statute, we issued this policy statement, and we subsequently brought lawsuits charging that certain employers' use of non-competes was an unfair method of competition. We followed this with a rule last January that would prohibit the vast majority of non-competes in employment contracts. As our proposal lays out, eliminating non-competes would free workers to pursue better, higher-paying jobs, and we estimate would raise the wages of all workers, including those not directly covered by a non-compete, by up to $300 billion a year. We received over 26,000 public comments in response to our proposal. Comments that recount devastating stories of how non-competes have kept people locked into abusive jobs, forced them to uproot their families, or buried them in expensive litigation. We're in the process of fully digesting these comments and look forward to finalizing the rule in the coming months. A third pillar of our efforts to protect workers is protecting their privacy. The FTC has long been on the front lines of protecting people's privacy as consumers of digital services, and we want to ensure these protections also apply to the workplace as well as to the marketplace. That's why in 2022, the FTC issued an advance notice of proposed rulemaking on commercial surveillance, a proposal that explores provisions to protect workers from surveillance in the workplace, which exploded during the pandemic as companies sought to closely track worker productivity. We've seen in recent years how firms can surveil workers' every move, be it their trips to the restroom, their precise keyboard strokes, or their participation in efforts to organize their workplace. These invasive tactics can amount to basic invasions of people's privacy and chill people's ability to exercise basic liberties. As research has recently captured, firms can also use this surveillance data to engage in personalized wage discrimination and impose a gamification of wages that could have sweeping implications across the economy. At the FTC, we are closely scrutinizing these developments and assessing whether they could constitute unfair or deceptive practices in violation of the FTC Act. As AI models and algorithmic decision-making incentivizes firms to further collect all the data they can get, the FTC is making clear that some data is simply off the table for model training. The major strides we have recently made to safeguard Americans' sensitive health, geolocation, and browsing data, for example, also critically apply to workers. Similarly, establishing protections on the type of content that can and cannot be used for scraping and model training will be essential. At a public workshop we recently held on generative AI and the creative economy, screenwriters, voice actors, authors, and others expressed deep concern about how it felt like their life's work had been appropriated and devalued by AI, essentially overnight. Across professions and trades, we've seen how questions of market structure shape the balance of power between workers and employers. When corporations have unchecked monopoly power, wringing out profits often comes at the expense of workers, consumers, and honest businesses. That's why protecting fair competition is an essential part of making sure that the bargain for America's workers remains intact. That regardless of who their employer is or how the law classifies them, they maintain the freedom to bargain, to take their labor elsewhere, and to earn a fair share of the tremendous value they create. As the FTC carries out its mandate, at every step of the way, we will continue to rely on workers and worker organizations as vital stakeholders in our efforts. And at a fundamental level, these issues boil down to the need for basic freedoms in and out of the workplace, freedoms that the FTC's mandate helps to secure. I'll end with an observation that Professor Block, you made recently about NLRB General Counsel Jennifer Abruzzo, whose commitment to upholding the rule of law on behalf of working people and in the face of incredible corporate pushback has been a huge source of inspiration for me. You said that seeing somebody stand up and say that the federal government is on your side when you want to stand up for yourself, that you're not doing it alone, is just incredibly important. My hope is that working people in this country, the thousands of people who have commented in our dockets, raised their voices in our open commission meetings, and showed up to town halls, can know that the FTC has a duty to safeguard their livelihoods from monopoly power. It's one that we're striving to uphold, and it's one that I ask all of you to continue to hold the agency accountable for in the years to come. Thanks so much, and I look forward to our conversation.
Samara's laughing because I go through this in class every week. Well, thank you so much. I mean, thank you for being here. Thank you for your service. Thank you for bringing workers to the antitrust table. And as Ben said, your tenure has been transformational in many ways, but for the purposes of today, in this evolution of thinking about the interests of workers and impact of mergers on labor markets, it's kind of become normalized because you've done so much. But it's really not that long ago where I think there wasn't very much attention about this intersection between antitrust and labor. I'm just curious, what brought you to thinking so about this critical relationship and addressing it to be such a hallmark of your tenure?
Yeah, it's an interesting question, and it is quite striking how quickly the public discussion and policy debate has shifted over the last few years. I think a few factors have driven that. One is just people more generally connecting the dots more clearly between the decisions that antitrust enforcers are making and how those connect to pain points in their day-to-day lives. It's no secret that antitrust in recent decades had become quite arcane, quite technocratic, had not really been on the forefront of how people think about economic policy making. And I think as that's shifted, people are really looking at the downstream effects of consolidation and monopoly power across the board, be it the effect on grocery prices or drug shortages or the types of jobs that are available or people's wages, new business formation, resiliency. There's really just an effort to look 360 to understand outside of consumer prices, what are the other downstream effects that we need to be thinking about? And so it's just been incredible to see that shift. I'll say for the FTC, we couldn't have done this without an enormous amount of engagement from unions and from workers. Our teams now are routinely in touch with unions. I mean, when you have a particular merger coming through the door that we know is going to have an outsized impact on workers, there are direct relationships now being built in ways that a few years ago people wouldn't even know who to start reaching out to. We've gotten so many comments from unions on things like our merger guidelines, our non-compete work, and so that engagement, while still, all things considered in its early stages, has already made just a world of a difference.
That's great to hear, because one thing I was going to ask you about is what you are seeing about the capacity on the labor side. I know, like, even in the Obama administration, we sort of started to touch in this area, and there wasn't a lot of capacity in the labor movement, people who really knew a lot about antitrust. And so are you seeing that capacity sort of ramp up as you're ramping up?
It is to some degree. I mean, I think there's still a lot of room for it to continue, but unions like the SEIE, for example, have just phenomenal research capacity and resources that are available for our teams to reach out to as they're just figuring out, how does this labor market work? What's really going on here? I'll also say that, there's a kind of research component of this, but there's also a grassroots element of this. Over the last few months, I've had a chance to do listening sessions around the country on the proposed merger between Kroger and Albertsons. This is one of the largest grocery mergers proposed in American history. And at these listening sessions, I mean, you had dozens of workers show up, extremely animated about this deal, sharing how the last time there was a big grocery merger, they saw layoffs, they saw stores be closed, Their communities are still suffering from grocery deserts that emerged because of those mergers. And so I think, again, we're seeing it more at the research, intellectual level, but also in a grassroots way in ways that I think is enormously exciting.
Yeah, I fully believe that workers are often the best experts about the companies at which they work and have such valuable information in terms of a lot of different enforcement strategies. It seems like another hallmark of this transformation around antitrust and labor in the Biden administration has been this like whole of government approach. I mean, from the competition executive order, which had over 70 different regulatory and enforcement actions. But then I want to drill down on the work that you've done in reaching these partnerships and memorandum of understanding with Department of Labor and the NLRB. How is that going? What are you seeing, or like, do you think you're most optimistic about the fruits of those partnerships? I mean, I don't think that's ever happened before.
Yeah, I mean, I think you're absolutely right that this has been a pretty transformational moment in terms of the focus that the administration has put across all agencies to really focus on how are our tools promoting fair competition, how are our tools really ensuring that workers are getting a fair shake. As part of those efforts, as you noted, we've been deepening our partnerships with other agencies, including DOL and NLRB. And really the goal there was, at a very basic level, to just learn how to start issue spotting for issues in each other's jurisdiction. And so sometimes, as we're investigating a merger or some type of monopolistic practice, we might see something that we think DOL or NLRB should be aware of. And so at a very basic level, having the ability to share non-public information, which you otherwise are not able to do, is much more seamless. Similarly, I think the work that the NLRB has been doing to think about how, surveillance in the workplace can be chilling workers' ability to organize, the recent work that they've done to address non-competes. I think we're starting to see how, even though each of our agencies has different purviews and different statutory authorities, there are real complementarities between our work, and so being able to do that shared work in a more clear-eyed, collaborative way is really helpful.
That's great. I love that. One area where it seems like at least your colleague, Commissioner Bedoya, has flagged a potential overlap of interests is around the problem of pervasive misclassification, which has so many ripple effects for workers. Can you share with us sort of how you're thinking about that question and where the FTC's enforcement tools may be helpful in addressing that? Is that a place where you are collaborating with like Department of Labor or the NLRB?
So this really stems from the restoration of our unfair methods of competition tool, where Congress very expressly said that the FTC's authority extends beyond the four corners of the Sherman and Clayton Acts. There have been efforts to really collapse Section 5 onto those other statutes, and so we've been undertaking a really concerted effort to make sure that the unique aspects of our Section 5 authority are fully used. In our policy statement, we do note that instances where firms are engaging in forms of lawbreaking that are giving them a competitive edge in the market can fall within our purview. I think we, just as a practical matter, from a resource allocation perspective, also just need to think about, where can we have the greatest impact given how resource constrained we are. One factor that comes into play there is what are the remedies that we can actually secure. So Section 5 of the FTC Act has no private right of action. We cannot get redress, we cannot get civil penalties, and so thinking about what is the remedial scheme for our statutory authority compared to the remedial schemes for DOL or NLRB, if they're able to say issue fines or issue penalties, which can have much more of a deterrence impact, that might be an instance in which it's better to let them take the lead. So I think it's really a case-by-case assessment, and so those are some of the factors that I keep in mind.
So following up on that, I think closely related to the question of misclassification is also this phenomenon that we've seen that our colleague David Weil has labeled the fishing of the workplace that often leads to misclassification, but also seems to have created a dynamic where the lead firm has just incredible control over the less dominant players in this fissured entity. I'm wondering what you see as the role that the FTC can play, is playing, not just among misclassified workers, but even some of the dominated firms within those fissured constructs.
Yeah, it's a really interesting question, and something that we, one reason why we put together the policy statement was to help connect the dots between some of what we're seeing in the fissured context with some of what we're seeing more generally in areas like franchising. Some of what we are seeing is business models that are consolidating control and power while shedding risk and liability, but also maintaining the ability to effectively dictate terms to be it workers or independent contractors or independent entities within their supply chain. Sometimes those are effectuated through what are known as vertical restraints, which have undergone a sea change in terms of how antitrust used to view them much more skeptically, but has come to view them much more permissively. And so that would be an area where revisiting some of those vertical restraints could be a potential path forward. I'll say more generally, I think this is another area where continuing to work closely with agencies like NLRB and DOL can be enormously useful, given how pervasive and prevalent these problems are, and how we also see a kind of trend towards increasing gigification across sectors, right? We've seen a whole bunch of ways in which certain parts of the healthcare industry are more and more moving towards this model, and so figuring out how we get it right here, it seems like it has much broader implications.
Absolutely. I mean, probably also just in shaping what that future looks like. I mean, the more obstacles, impediments you put to, or consequences to the gigification, maybe that actually inhibits some of those business models. So
one more thing I should add: there were a series of really interesting lawsuits a few years ago that basically tried to get some of these gig companies to choose a side, because these companies often are both saying that, for example, independent or the drivers are not employees, they're independent contractors, but then these gig companies are also effectively setting wages and, you could argue, effectively coordinating or facilitating price coordination or price fixing. And so there were some interesting lawsuits that were saying, okay, you either have to choose one bucket or the other bucket. And so I think legal strategies in that vein also continue to be useful to try to target some of the shape-shifting and kind of strategic evasion that we see.
I agree, those were really fascinating. I'm going to come back to the non-compete rule. So amazing, you've gotten, what you said, more than 26,000 comments. I mean, not surprising now, knowing how prevalent these non-compete agreements are. And there's a way of thinking about non-competes as an impediment to worker exit, which there are ways of thinking about workers building power, both through the power to exit and then the power to act collectively. Are there other strategies that you're thinking about in terms of the tools that you have to address constraints on worker exit? Is non-compete sort of the biggest threat you see now to workers being able to use that leverage?
Yeah, I mean, you're absolutely right that the kind of tool of competition is an exit promoting one. I think non-competes has jumped to the top of the list in terms of the prevalence of it. But I think you're right that we could envision seeing other similar coercive tools. No-poach agreements are another form of limiting exit options, and we've seen in lawsuits brought by the DOJ and state AGs allegations around how no-poach agreements can be quite prevalent, especially in markets that are more consolidated. And so we've seen how more consolidation actually enables coordination among employers, which I think is just an interesting question empirically, right? We've seen how in some instances when mergers are proposed, those mergers are used as leverage by existing unions or workers that want to organize to try to extract those commitments at that moment of the merger. But given that consolidation more generally can allow employers to better coordinate, I think there's just a basic question about, is the net gain there, especially over the long term, one that's really going to redound to the benefit of the workers if they're structurally losing some bargaining power and negotiating power as markets consolidate. As I've had the chance to sit down with various unions over the last year, it has been interesting hearing from them about how, as some of these markets have consolidated, they actually have seen some of these employers try to coordinate more closely as they're negotiating with the union, and so I think that type of coordinating activity is just always interesting to see and potentially illegal.
Right. Okay, so now I have a question. It's gonna maybe sound like it's coming out of left field, but I just can't resist having you here. In that that category of maybe coordination that's right under the surface but not out in the open, I wonder what if you think there's any application of the FTC Act to this really dramatic growth that we're seeing in the industry of anti-union consultants, what Department of Labor calls persuaders, these firms that design and run anti-union campaigns for employers. Is there anything there if employers, say, in the same sector are using the same consultant to run similar campaigns? Is this anything that has come up before? Any thoughts on this favorite topic of mine?
It's a really interesting question. Not something that has directly been teed up for us, but I think you're right that if you think about things like the kind of hub and spoke model where you have a central entity that's facilitating illegal behavior across some of these independent businesses, that is something that can be in the crosshairs of the antitrust laws. You'd obviously want to look closely at the facts, how much coordination is there really in terms of where they're ending up. It has been interesting to see how, there have been efforts to suggest that firms agreeing to certain ESG commitments, for example, could be engaging in that type of unlawful coordination. We've seen some state AGs get very animated about that, and so that's a place where some of those principles, if they apply in that context, maybe you could apply in this context too.
Okay, last question, then I definitely want to get to this amazing group. So we talked a little bit about the kinds of partnerships and memoranda of understanding that you have with the labor agencies. Are you seeing more activity in the states around coordination, in the good sense, between antitrust enforcers and labor enforcers, or other indications that this kind of interest that you are modeling is having ripple effects out at the state level too?
Yeah, so coordination among law enforcers, legal. We haven't directly engaged with labor enforcers at the state and local level, but it's an interesting question about what the possibilities there could look like. Certainly the state AGs as a whole have become extremely active on the antitrust front, in particular over the last few years, including in a whole set of really cutting-edge areas. And, in addition to directly working with state authorities on law enforcement investigations, we've also been doing things like submitting letters to legislatures, showing up and offering testimony on bills that legislatures are considering. And so that type of policy advocacy to state lawmakers has been another key lever that we're using.
Okay, I'm sure you all have lots and lots of questions, so let's open it up. We've got a couple folks with microphones that can make sure that we can all hear you coming around.
Hi there. Thank you so much for being here today. So one issue you touched on that I'm really interested in and concerned with is the misclassification of gig workers as independent contractors and the effect that has on their ability to organize. So cases like Superior Court Trial Lawyers Association have been understood to mean independent contractors' ability to organize has not been protected by the antitrust labor exemption. But the basis for this view has been challenged recently in the First Circuit. So 2 questions. How do you think the FTC can counteract existing or legacy doctrinal hurdles inhibiting the organization of workers? And also, do you think recent case law can be viewed as a signal that courts are reevaluating this doctrine?
Yeah, it's a good question, and certainly that First Circuit opinion was a really terrific one, and I think takes a more realist, functional view of both what the law says, what the intention was, and accounts for changes in the economy. So look, it's no secret that the antitrust agencies have a bit of a history here of weighing in on some of these efforts by independent contractors, gig workers to be trying to collectively organize. Since I joined the commission, we have firmly broken with that past and said we're not going to be devoting resources to weighing in on attacking the efforts of workers to be trying to organize. So that's just a very basic resource allocation question. We continue to look for amicus opportunities and other opportunities to be explaining to the courts how we think the exemption under the Clayton Act should be applying in some of these newer contexts. We also, in letters to Congress, I've noted that it would be great for lawmakers to further clarify how the exemption in the Clayton Act affects and also covers workers regardless of their formal employment status. And so continuing advocacy with the courts and Congress will continue to be a key area of focus for us. We are currently thinking whether, across the board, whether there are policy statements, letters, positions that the FTC as a whole has taken that we want to be rescinding to more formally note that some of this prior guidance or these prior positions are outdated and no longer reflect the position of the Commission. So we'll hopefully be able to share more on that in the coming months.
Here. Yeah. You're looking.
Hi, thank you so much for coming to speak with us.
Introduce yourself.
Oh, hi, I'm Josh. I'm a 3L here at the law school. Thank you so much for coming to speak with us. I guess I had a question about whether the effects of textualism and this focused on text and history has been overall more beneficial or more harmful to the FTC's desires to regulate? Because you would think as a historical matter, your side seems to be the more historical side, the consumer welfare standard coming much later. And I'm curious how that might have played out, regardless, pragmatically.
It's an interesting question because there has been somewhat of kind of antitrust exceptionalism as we've seen certain methods of statutory interpretation gain much more currency, like textualism. That's kind of applied across the board except for antitrust, right? I mean, there are very clear ways in which governing interpretations of the antitrust laws are flatly atextual. And so our efforts with the FTC Act have been in part motivated by wanting to be more faithful to the text of the law as well as what Congress really meant there. I think, it's still waiting to see how that fully plays out in court. I would say this is an area where there is interest more generally, including in some conservative circles, to be revisiting, what is the common law history of the antitrust laws and how do we, if we're going to be principled in how we value certain statutory interpretive tools and give them more primacy, as part of that more principled exercise, let's figure out what it would look like for antitrust. And so there is some interesting research and scholarship underway that will be interesting to follow as well.
Hi, I'm Samara at Matuel. I've already asked you a lot of questions today, but I'll give you one more. This is a question I've had for a while about antitrust theory. So you've talked about employer surveillance and coercion in the context of unfair methods of competition. I'm curious why coercive employer surveillance and control, especially outside of work, isn't seen as a vertical restraint of trade. So if you have things like employer housing and geolocation that are essentially like a corporation reaching outside the boundaries of the employment relationship to control and input into their supply chain, which is those workers' labor, I'm curious why we don't think about that as a vertical restraint of trade.
Yeah, it's a really interesting question. I don't see off the top why it necessarily wouldn't be. I mean, I think as a general matter, how we apply some of these enforcement tools and principles to some of these new contexts, especially in the worker context, especially in the worker surveillance context, are still pretty nascent. So that sounds like a great law review topic.
Other questions?
Thanks. Hi, I'm Nick. I'm a 3L. Thank you so much for the great conversation. I was wondering how you think, if you think it is material, about businesses' ability to offshore or outsource labor when you're taking these competition-related actions that have labor market effects.
So you mean when we're thinking about mergers, for example?
Mergers, specifically the non-compete proposal that you put forth recently, I can just think of businesses, perhaps on the margin, instead of employing workers here in the US, particularly if it's in like a tech-related job where the work could be remote, instead going to a different country where there's more favorable labor laws or labor regulation for them.
Yeah, I mean, I'd be curious to hear from the labor law experts, but my assumption is that that's always a risk, right, across the board. Like the logical endpoint of focusing on that risk means let's not have labor protections at all, because there's always going to be a race to the bottom, and we have to be at the bottom. I do think that we are seeing, as with the industrial policy strategy of the administration, a shift towards trying to focus and prioritize Made in America, and making sure that as we're reshoring, that those jobs are going to, say, unionized workers. And so there does seem to be, to my mind at least, an effort to be thinking about the labor consequences of some of these non-labor, non-strictly labor policies in a way that I think is really useful. It's no secret that there have been ongoing discussions to potentially be entering into a new trade agreement. I'm sure these issues will come up there as well.
Hello, I'm Nita. I'm an SJD student here. So I have a bit of a broad question that I work on, but when making policies, how do you weigh between the interests of small employers, like small businesses, and workers, especially when they conflict?
Are there specific examples that you're thinking of?
Well, yeah, specific examples in terms of, so for example, like in a lot of like statutes or core labor and employment rights, small employers are excluded based on their size from regulation, and those workers end up missing out on those rights. And like as competition law authority, like small employers and protecting small employers seems to be also like one of the purposes of like regulation. But then what happens when they conflict with workers' interests?
Yeah, so as a general matter, the antitrust laws don't allow us to trade off harms to one set of participants in favor of benefits to the other. So if we find that there is a law violation with regards to one set of market participants, be it workers, be it small businesses, those law violations are not then overridden by benefits provided to somebody else. So that's just a general principle across the board. As a practical matter, when we think about resource allocation, we're a pretty small agency. We're like 1,200 people, and so we try to focus on where do we see the most harm, the greatest magnitude of harm, which practically oftentimes means the biggest companies. We also think about factors like if we don't take action, will somebody else? Given that there are private rights of action under the antitrust laws, if the harmed parties are primarily really well-resourced, really well-heeled, big corporations, then presumably they should be able to vindicate their own rights. We also think about factors like, is this an area where particular business practices or particular business models are just starting to take root, such that if we act now, we could send a really important signal across the market that could prevent some of these practices from becoming much more deeply baked in. One example on the consumer protection side is, or more generally with digital markets in the early 2000s, there was a general sense across DC that the best thing for policymakers to do was just to get out of the way. One consequence of that has been that certain business practices that in hindsight policymakers are realizing were actually pretty exploitative, have huge downstream consequences in terms of, decimation of independent journalism, to real harms to teen mental health. Those types of business models and practices are much more deeply baked in now than they might have been if enforcers had taken action 15, 20 years ago. So that's another criteria that we generally think about. Timeliness, do we have the ability to impact the market in a more significant programmatic way such that our taking action is worth it?
Yeah, okay.
Hi, thanks so much for coming. My name is Lainey, I'm a 2L. I was wondering what you think of the potential of Chevron deference being overturned and the impact or curtailed significantly, and the impact that could have on the FTC's ability for enforcement actions.
Yeah, obviously there are major questions being teed up for the court as it concerns independent agencies. The Chevron question is a big one. As a practical matter, the vast majority of the rulemaking that the FTC does is not under the APA, it's under the Magnuson-Moss Warranty Act, which lays out a higher and more stringent set of procedural hurdles that we have to go through. So, that rulemaking would not necessarily even be governed by Chevron. It would likely be something more deferential given the heightened procedures that we have to go through. The Chevron question will probably most directly implicate our unfair methods of competition rulemaking, which is the authority under which we're promulgating the non-competes rule. And so, depending on how that shakes out, we'll see what happens. I would say just more generally, there are a whole bunch of cases being teed up for the court, some already before the court, relating to the constitutionality of administrative agencies. That's just generally been a backdrop through the last few years, something that's affected most immediately our ability to do in-house administrative adjudication. Right now there's a question about the constitutionality of the 2 layers of protection for ALJs. Some of these issues are going to be affect the agency more than others. The ALJ one's a pretty significant one, but given the ramifications across the administrative state, you would think that's probably going to be something that, if it goes a particular way, will be resolved by Congress much more directly. I think there are other questions that would affect the agency much more directly, which, there, I think, is a relatively closed universe of these legal questions, and we just have to wait out when they get resolved to provide more clarity.
Hi, I'm Tasha. I'm a 3L here and an MPP at the Kennedy School. You mentioned workers showing up to public comment and unions doing research. I was wondering if there's anything else that you think would be helpful for advocates and academics to do for the FTC to be able to advance its mission, and perhaps other agencies in the labor space as well.
I love this question. There's an enormous amount that we need to be done. We should connect with you directly so we can be feeding you some of the research questions that are top of mind for us right now. More seriously though, I think there is this basic question around what is the optimal market structure for workers from an organizing perspective, right? We talked about this a little bit earlier. It's probably not a monopoly, right, given what we've seen about the leverage that unions derive from being able to effectively play employers off one another. And so I think as some of these questions come up, more just empirical research into historically how have these mergers fared, especially when these companies are making commitments about how more consolidation will actually be better for workers. Has that actually been the case, right? I think there's just a basic empirical question. As I mentioned, some of the commitments that we see firms make about increasing jobs don't pan out, and more often than not we see layoffs. But I think there are other key dimensions of workplace quality, pay, other aspects where I think it would just be interesting to see more research to figure out is more consolidation among employers actually better for workers. I think there's a whole bunch of research that suggests not, but I think especially as we see some of these deals and the strategies that worker organizations decide to pursue, I think it could be really fruitful.
Here on the aisle.
Hi, my name is Samantha. I'm a 2L at the law school. So I'm taking forced arbitration this semester, and we read an article of yours about arbitration as wealth transfer. And I'm curious to know if the proliferation of forced arbitration agreements is a major concern for private antitrust enforcement, and if so, what the FTC is doing in response.
Yeah, it absolutely is a factor that I think has contributed to some of the drop-off that we've seen in certain areas of antitrust enforcement. That's also actually, as we were thinking about our non-competes work, the factor that played into the decision, the fact that Section 5 of the FTC Act doesn't have a private right of action, but even if these non-competes are illegal under other statutory bodies, the presence of an arbitration agreement in many of these employment contracts would probably make it unlikely that workers would really be able to vindicate those rights, and so there was particular value to us acting there. As a general matter, that feeds into how we think about our case selection. If we worry that there are certain practices that could potentially be illegal under the antitrust laws, but we're not seeing private lawsuits, in part maybe because of those arbitration agreements, that's something certainly that we would think about. As a general matter, we're also looking more systematically at the private litigation that's currently ongoing and thinking about, where might the courts benefit from amicus participation from us. How do we work more strategically with the private cases that are out there as well, given that there are only so many cases that we ourselves can file.
Here in the front.
Hello, hi. Thank you for your talk and for your work generally. Alex, I'm on exchange here, and I was wondering, as you mentioned, concentration in labor markets is quite different from concentration in product markets. A lot of economic research seems to suggest that. So how are you planning to translate existing market definitions and thresholds and principles that have been established for product markets to merger reviews that concern labor markets?
So the revised merger guidelines lay out some of this, both in the specific guideline that talks about labor, one of the later chapters that talks about our economic tools and methodologies also describes how some of the tools that we apply in product markets might translate in the labor market context. As a practical matter, as we're doing these investigations, it comes down to knowing what information to be requesting. Right, so as you're thinking about what's the relevant labor market, knowing to get certain types of commuting zone data, figuring out what are other metrics that can really give us insight into what is the extent of competition between these two entities as employers. Functionally, that can significantly increase the scope and scale of the investigation, and so sometimes you're basically doubling the work by deciding to look at the labor side in addition to the consumer side. But we've decided that programmatically it's really important for us to invest in figuring out how do you do the labor side investigation. It's oftentimes going to be easier to just do the consumer side, but unless we develop the tools for the labor side, we may be in situations where there's no problem on the consumer side, there is a problem on the labor side, but because we haven't developed the tools, we're not able to fully capture it. So it's work that's undergoing. We have a really terrific set of economists and researchers in-house. The agency has really been building out its ranks of labor economists these last few years as well. And so as they're developing more methods and tools to be figuring out how do you analytically capture some of these questions, I think that's work that we'll continue building on as well.
I think we have time for one more question. Gone over here, yeah.
Thank you, Chair Khan. My name is Ben Dinavelli. I'm a 3L and a former FTC intern, actually, so thank you very much.
What division were you in?
I was in Mergers 3 with Peter and Brian and Jessica.
Great.
Yeah. I guess I'm curious, like, in an ideal world, obviously, you would pursue every kind of violation of the antitrust law and pursue every potential rulemaking under FTC Act 5. I guess as like a practical matter, you only have so much time and so much resources. How do you decide when to go after the more, I guess for lack of a better word, traditional bread and butter antitrust violation or case versus trying to push the doctrine, whether through challenging a particular merger or pursuing new rulemaking?
Yeah, it's a difficult thing to be figuring out, and there are difficult trade-offs that we have to make. On the merger side, it's a little bit easier because we are primarily reactive, right? We don't control what comes in through the door. Even there, though, there can be difficult questions around, where to be focusing our resources. Again, magnitude of harm, the significance of the industry really matter. And so a merger that's going to hike the price of life-saving drugs, we're going to prioritize differently than a merger affecting yacht owners, right? Just as a practical matter, the public interest matters, and how some of these deals are affecting real people who are oftentimes in precarious situations really matters. Beyond that, it really goes back to some of the other factors I mentioned. If we don't act, will other entities step in, be it state enforcers, be it private enforcers, well-heeled companies? Is there an opportunity to be advancing the law? Is this a particularly strong set of facts for particular legal theories or particular opportunities to be clarifying to the court how some of these age-old antitrust principles apply in their context? I think the relative dearth of monopolization law over the last couple of decades has really been a disservice to antitrust as an enterprise more generally, right? We only recently have started to get the courts to grapple with, how did the Sherman Act, the Clayton Act apply in some of these digital markets? And so as we start seeing some of these institutional feedback loops between the cases the agencies bring, how the courts render their opinions, and then what Congress gleans from that in terms of whether they think that the courts are getting it right and all is well with the antitrust laws, or whether they decide that actually we're seeing from these cases that there are key gaps and we need to amend the laws. I think that type of institutional feedback between the different actors is an incredibly important part of antitrust enforcement. I think a key premise of antitrust being built around these fairly general sweeping prohibitions was that you would see an evolution of the law as markets change, as business practices change, as technologies change. If in fact it's not true that courts are going to be able to accommodate that evolution of the law, then I think that's something that Congress really needs to be on notice about.
Wonderful. Well, please join me in